I think he should be done.
It'll be me again. You got nothing to say.
Mr. Martinez, have you all finished with the paperwork? Are you guys done with the paperwork?
He's been sworn already, Judge.
All right, so if I can get the paperwork on him, we will take that matter up.
He says he was sworn. I wasn't.
Okay. Are you okay? Here's some water. Here you go. You got it?
He's been sworn.
Yeah, he was sworn.
Judge was asking.
He was sworn in, Judge. All right, if I can have his file, it's an update. We will go. There should be a. Thank you. We do. And you know what? No one ever calls while I'm on the bench anyway for me to answer. So. Yes, I think we're going to have to do that. Hopefully it doesn't affect anything. We'll see about moving it.
Yes.
All right. Are the parties ready on Joseph Ramirez?
Yes, sure.
All right. So which cases, Mr. Ramirez, you can come up. Which case are we proceeding on? Is it more than one?
I believe so, Your Honor. So I didn't work up the plea on this one.
Okay. Thank you. Okay. So it's the top three that we're proceeding on. All right, Dinah, are you okay with proceeding on 3 cases at once? Okay. I love when people say whatever you want.
Yeah, no.
Let me just move this around and then we will take it up. I'm sorry, you ready? Okay. Oh, just don't go real quick. Oh, all right. Thank you. All right, the court is calling 2021 CR 8065B, 2021 CR 8077B, 2021 CR 8084B, State of Texas versus Joseph Ramirez. Could I have parties announced for the record for the state?
Officer Salinas.
Defense?
Raymond Martinez.
And are you Mr. Ramirez? Counsel, in each of the cause numbers, I'm showing you the discovery acknowledgement. Have you received the discovery in each of these cause numbers and did you review those with your client?
Yes, Your Honor.
In each of the cause numbers, the court will find that the state is in compliance with discovery. Are there applications in some and applications not in
In the
others?
third one, Judge, yes, there is.
Okay.
Just the one.
So there's only one with an application, is that
Yes.
correct?
Yes.
All right. Mr. Ramirez, in cause number 2021 CR 8084B, showing you what's entitled application for community supervision. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am, I did.
And each of the cause numbers, I'm showing you what's entitled true bill of indictment. Did you review those documents with your attorney? Did you understand them? Counsel, do you waive the reading of the indictment in each of the cause numbers?
You do, Your Honor.
Stating cause number 2021 CR 8065B. Are you proceeding on the indictment as presented?
No, Judge, we're waiving the banning the repeater allegation. Oh,
I'm sorry, I was thinking about another case.
Yes.
Yes, we're proceeding that way.
And in cause number 2021 CR 8077B, are you proceeding on the indictment as presented?
Yes, sir.
And in cause number 2021 CR 8084B, are you proceeding on the indictment as presented?
In that one, we're waiving the repeater.
Any objections to the waiver?
No, Your Honor.
And each of the cause numbers for Mr. Ramirez, I'm showing you what's entitled Court's Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review those documents with your attorney? Did you understand them? And did you sign them in all the appropriate places? In cause number 2021 CR 8084B, you're charged with the offense of tampering with a government license or seal. That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am. I did.
And cause number 2021 CR 8065B, you're charged with the offense of fraudulent use or possession of identifying information, 5 items or less. And then also in 2021 CR 8077B, you're charged with possession of controlled substance, penalty group 1, less than 1 gram. Each of those offenses are state jail felonies. The range of punishment for those offenses is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes.
And each of the cause numbers, if you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea or gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? And each of the cause numbers, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. Did you understand?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into plea bargain agreements in each of these cause numbers? I'm sorry?
Yes.
Counsel, has your client been able to provide you with any defenses?
He has, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Ramirez, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Has anyone promised you anything other than the plea bargain agreement? Are you satisfied with the way you've been represented?
Very well satisfied.
Are you a U.S. citizen?
Yes, ma'am.
In each of the cause numbers, the court will find that the defendant has knowingly and voluntarily waived jury trial. Showing you what's entitled plea bargain page. Did you review that page in each of the cause numbers with your attorney? Did you understand it?
Yes.
And cause number 2021 CR 8065B and 2021 CR 8077B, according to the plea bargain agreement, you're to be sentenced to 100 days in the Bexar County Jail under 12.44 of the Penal Code. The cases are running concurrently. The state is taking in consideration 2021 CR 8072, 2021 CR 8076B, 2021 CR 8064B, and cause number 2021 CR 8084B, according to the plea bargain agreement. Punishment is to be assessed at 6 years in the prison. There's a $1,000 fine. State recommends community supervision. Cases were run concurrently. The previous cases stated are taken in consideration. However, there will be restitution in 2021 CR 8072. There's to be restitution in 2021 CR 8084B, 2021 CR 8065B, 2021 CR 8064B, 2021 CR 8076B, and there's to be no contact with any of the complainants in the cases. Did you understand that to be the plea?
Yes, sir.
And each of the cause numbers, I'm showing you what's entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in all the appropriate places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there any such motions?
No, Your Honor.
And cause number 2021 CR 8084B, Outside the plea bargain agreement, the state is requesting that your supervision be for a term of 6 years and there be 40 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? Did you understand?
Yes, Your Honor.
Then how do you plea in cause number 2021 CR 8065B? Guilty, not guilty, or no contest? And in cause number 2021 CR 8077B, how do you plead? Guilty, not guilty, or no contest?
No contest.
And in cause number 2021 CR 8084B, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Yes, Judge, state offers in each one of the cases, State's Exhibit 1 and its attachments.
No objection, Your Honor.
In each of the cause numbers, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review those documents with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
And each of the cause numbers, the court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, in cause number 2021 CR 8065B, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We are, Judge.
Court will follow your agreement, sentence you to 100 days in the Bexar County Jail under 1244. Give you credit for any time served. This will run concurrent with 2021 CR 8077B and 2021 CR 8084B. Taking consideration 2021 CR 8072, 8076B, and 8064B. And that cause number, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, with that, we're going to move on to 2021 CR 8077B, and the court is reviewing state stipulation for sufficiency. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
We are, Judge.
All right, the court will follow your agreement, sentence you to 100 days in the Bexar County Jail under 1244 of the Penal Code. Give you credit for any time served. This will run concurrent with 2021 CR 084B and 065B. Take in consideration 2021 CR 8072, 8076B, and 8064B. Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, next we're going to move on to 2021 CR 8084B. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Please ask the court to follow the plea agreement, Judge.
All right. Mr. Ramirez, are you employed?
Yes, ma'am.
What do you do?
A carpenter, ma'am.
I'm sorry, what?
A carpenter and the superintendent
Superintendent for what?
for a construction company, ma'am.
Who is April Gonzalez to you?
That's my wife.
It appears that you all are committing crimes together. So do you have any children?
Yes, ma'am.
How many?
Total of 3, 2 that live with us,
What are their ages?
17 and 15.
Why are you stealing?
I don't know. Got lost in our ways, I guess.
I'm sorry, what?
Just got lost in our ways, just. I have no really reason for it.
Just one moment. So are there any drug issues?
No, ma'am.
So why are you stealing though?
I don't know, ma'am. I'm confused.
I'm sorry, what?
I don't know what's happening.
Well, I mean, it appears that you're going in people's mailboxes, you're doing this, you're doing that. When's the last time you spoke with April Gonzalez?
Last time she was about a month ago, I guess. She was incarcerated as well. So
You both are setting a horrible example for your children. I mean, you're telling me you're a carpenter, but it appears that's not your occupation. Your occupation is taking things that don't belong to you. So I'm telling you right now, you're going to get a real job. And when I say a real job, I know that carpentry is a real job, but it appears that you're not really working on a basis that supports you. So you're getting a job and you're going to get a job where someone actually pays you with a paycheck. Do you understand? All right, this is what the court is going to do. Punishment is going to be assessed at 6 years in the prison, suspended and probated for 6 years. There's $1,000 fine that will be probated. This run concurrent with 2021 CR 8077B, 2021 CR 8065B. Taking consideration 2021 CR 8072, 8076B, 8064B, restitution, if any, and no contact with complainants and cause numbers 2021 CR 8072, 8084B, 8065B, 8064B, 8076B, 120 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to get the COVID vaccination, but if you do with booster, 40 of those hours will be waived. Parenting classes with triple P regular reporting by Zoom or in person. I'm going to want field visits 2 times per month. And probation, if you can let them know that they're going to need to search and make sure that there are no items that have information on it that does not belong to him or his wife. And don't go out there putting items in your children's names. They need to start with a clean credit report. You understand? We're going to do regular UAs. We're going to do the MRT with him. Probation, is there anything else he needs? Thank you. Proof of employment within 30 days. There should be no employment as a home health care provider or with minors, and his employment needs to be at least 8 hours a day. And if you need to get 2 part-time jobs to make 8 hours, that's what you need to do. Do you understand?
Yes, Your Honor.
Is there anything else you need from the court in order to be successful?
Take a chance.
All right, you better stop stealing. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, Your
Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Honor. Yes, Your Honor.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to your attorney. Do you understand? All right, we can go off the record. You had better start searching internally why you do the things you do, because you're going to find yourself maybe in prison for a long time. And then your children will not be influenced by you, possibly, because you'll be at the prison. You understand? All right, good luck to you. Thank you, Mr. Martinez.
Thank you, Judge.
Thank you, sir. Yep, you're going. Yay.
Okay,
Oh, man, are you serious?
Serious.
Oh, yeah.
Caroline, here you are. Bryce Clark.
Yeah, I know. Because
All right, the court is calling 2022 CR 8299 State of Texas versus Bryce Denver Clark. Could I have parties announced for the record for the state?
Jason Gearhead for the state, Your Honor.
Defense?
Matthew Brown, Mr. Clark.
And are you Mr. Clark? Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery and did you review it with your client?
I have, Your Honor, yes.
Court will find that the state is in compliance with discovery. Showing you, Mr. Clark was entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We waive, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, we are.
Mr. Clark, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places? Did you understand you're charged with assault, bodily injury on a security officer? That's a 3rd-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine.
Yes, ma'am.
Did you understand if you have a plea bargain agreement with the state, the court does not have to follow your plea? If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights? And did you intend to give up those rights and enter into a plea bargain agreement in this case? Counsel, has your client been able to provide you with any defenses?
Yes, he has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Clark, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 2 years in the prison. There's a $2,500 fine. There are no applications. The state will take in consideration 2022 CR 11446, County Court 12 cause number 693877, 674221, and 693879. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
It is, Your Honor.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Then to the offenses charged in the indictment, how do you plead? Guilty, not guilty, or no contest? State any evidence?
Yes, Your Honor. State, offer state exhibit number 1 with all its attachments.
No objection.
Mr. Clark, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
All right. Could someone tell me the complainant, who the complainants are in the cases that are being taken in consideration? And that would be the 69, the county court cause number 693877.
Those, are those the terroristic threat case?
Yes.
Yeah, one's terroristic threat and one is the interference with the
So-
911 call.
It's Sarah Webb. It's the same victim who's on the felony cases being PIC as well.
Okay. And is that person aware of what's going on?
They're uncooperative, Judge. We haven't had successful contact with them,
All right.
but we've attempted contact.
All right. Thank you. Court will follow your agreement, sentence you to 2 years in the prison, give you credit for any time served. There's a $2,500 fine. Time and money will run concurrent. Take in consideration 2022 CR 11446, 693877, 674221, 693879. And there's to be no contact with Sarah Webb. That's SARAHWEBB. All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it? Thank you. Did you review that with your attorney? Did you understand it and did you sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? Because this is a felony conviction, you're not allowed to, that's okay. You're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. Good luck to you. You're gonna have to change your ways. Otherwise, you may find yourself in and out of prison, in and out of jail. And I don't think you want that, right?
No, ma'am.
All right, good luck to you.
Thank you, Your Honor.
You're welcome. All right, who do we have left on the docket for trial? Okay, can I see the file? All right, can you call Mr. Garcia?
Oh, wait,
And if you want to set up for the trial, yes. go ahead.
Yes.
All right, and Richard Garcia's case, Raul Reyes, that is family violence, okay. All right, so if you all can tell me, how much time do you need for jury selection on Brian Parker?
30 minutes each side.
Okay, so what we'll do is we'll do jury selection today, then we'll start with testimony tomorrow. Is everyone okay with that?
Sure, what time tomorrow?
Oh, tomorrow is Wednesday. We'll start at. Okay, we'll start tomorrow at 10 for jury trial, but we have a small docket in the morning.
Okay.
And has he filed his election?
Yes, sir.
Okay, thank you. All right, so Mr. DeWalt, I don't think you've been in trial with us before, and I know Ms. Jagirhan, it's your first time, but this is the way the court does jury selection. So the 30 minutes you're asking for, you do specific and general in that time. I will keep track of people I deem may have strikes for cause, but I always have you all confer. And if it's something you can agree on, then usually I follow that. If it's not something you agree on, then I can make the call to that. Right?
Sure.
Right. Okay. Are those officers for you all? Or are they for me?
Not for us that we're aware of, no, that I'm aware of.
Deputy Laura, are the officers out there, are they for me?
Mr. Reyes, I'm assuming if this case goes, case will be reset.
Yes. So we're just waiting for Mr. Garcia.
I have a big trial right now. Run. Okay. Okay, thank you, Judge.
Hey, did you take my county clerk vote? Oh, you gave it to the discount. Oh, yeah. That's fine. Oh, what?
He wants to go get paid for it, I'm sure.
Jeez.
Brian Parker. Yes. All right, Mr. Reyes, if you can come forward, please. All right, Mr. Reyes, on your case, we're starting jury trial on this. So if you can wait out in the hallway, we're going to wait for your attorney so we can get you a reset form. Do you have your attorney's contact information?
I have his number. I usually text him.
All right, if you can text him and let him know to come in, and then we'll get you your reset, okay? All right, thank you. So just wait outside in the hallway, and then Ms. Ferguson will get with you and your attorney.
Yes. Oh, we went to go take one guy down, but the other guy's not there. You need to see him, right? Yeah.
Thank you. And can you see if they have, let me see if I have.
I do that.
Thank you.
I like the old way better.
Do we get a separate sign out sheet?
Have you seen it like this before?
Yeah.
I haven't
All
seen
right,
it.
so there's no enhancement on this, correct?
No, Judge.
Doesn't
No.
hurt.
So just 2 to 10.
Right.
Okay. Yes, thank you.
Yeah, you're used to the little boxes, right, Jason?
Huh?
You're used to
Yeah,
the
I'm
little
used to, I'm
boxes.
used to the little,
Yes, get them lined up.
like you cut them in strips, wherever they Xerox them, remember that? I like that one. I have them something else.
Is this your water?
Yes, it is. My apologies. Thank you.
I'm sorry.
My.
Sure. It is here. Is it showing? Let's see what's going on here. Oh, just 1 second. Mhm. All right, thank you. I'm sorry, what? Oh, I have it too. There too. Mhm.
I'm done. I just finished.
Okay.
Hmm? Yes, is that good or not?
Okay.
How do you turn it off?
Oh, no, don't worry, I got it. I have all of them off because.
Yes, is there something?
No, I'm gonna bring those forward out this year. It's that one that I was. This is like.
Okay. Thank you.
So she could hear you, so there you
Okay, awesome. And is it just me or is it hot in
It's
here?
hot. It's
Can-
27 degrees.
What's up with 25, 28? I don't want to answer questions. 29?
I slept in.
All right, could you let them know that we are burning up in here?
75 degrees. Maybe a little temperature stay, is that what it says?
No, it's the bottom one, 76.6.
Oh, 76, geez, I thought it was 59 degrees in here.
Yeah, and then when the jury comes in here, it's gonna be hotter.
Oh,
Okay. All right, everyone, let me know when you are ready. Oh, sure.
Not tonight. We're picking the jury today. And the trial this month. $50 for 2 hours.
Fatima Connor. This is the information. Yes, Fatima Connor, but
I'm not even
this
saying
is
it's all right.
just email me. I haven't had time to look at it. I just saw it pop up. So, okay.
All right. We can bring them in.
Oh, hey, did you want to see the PowerPoint or not?
I'm not. Doesn't say guilty real big, does it?
No. Not that I can recall.
Blood stains everywhere.
Minutes, Judge.
Oh, 2 minutes. Okay.
Yeah, we're getting close.
All right, we're getting
They're all
close.
scrambling.
Okay. And then Norman, have you had contact with Richard Garcia?
No, no. I'm texting. I'm sure.
Oh, no. You're good. Thank you. Okay. So that's family violence, so it needs to be set to a jury trial. So what date? Oh, he is going to be gone. He won't be back till March. So give them a March date for jury trial. I don't think people will agree to let him Zoom from Egypt. Yeah.
Everybody's going to Egypt. Judge, we need to go to Egypt. Mejia was there last year.
We should do it. You know, we should do it as a bonding exercise.
I like that.
All right, let's put it there then.
Your Honor, we are missing 3. We did have a few jurors that called in yesterday.
All right, so what 3 are we missing?
Number 9. That person is sick. Number 19. No call, no show. And number 43. No call, no show. And the people that did call yesterday are here today.
All right. The court is going to call 2022 CR 6496, State of Texas versus Brian DeAnthony Parker. Can I have parties announced for the record for the state?
State of Texas, Jason Darien.
Defense?
Sorry, Eric DeWalt, I represent Mr. Parker.
All right, and are you Mr. Parker?
Yes, ma'am.
All right, are both parties ready for trial, state,
Yes, Your Honor.
defense?
Yes, Your Honor.
All right, I've been informed by the deputy that jurors number 9 is not present and juror number 9 is not present due to being ill. Any objections to excusing that person?
None from the state, Your Honor.
No, Your Honor.
I'm also being told that juror number 19 and juror number 43 did not show. Any objections to excusing them?
No, Your Honor, none from the state.
No, Your Honor.
All right. With that being said, then we will proceed. Are both parties ready to begin jury selection?
Yes, Your Honor, and just for the record, the state did provide a discovery acknowledgement defense right before we started up. Just wanted to make sure that got turned in.
All right, and the court has the discovery acknowledgement. Defense, have you had a chance to review the discovery that the state has tendered, and have you had a chance to review with your client? All right, the court will find that the state is in compliance with discovery, and we'll bring the jurors in.
Number 1, first row all the way to the end, and it has a number on the seat. 2. First row, as number 8, who's number 7, 8. Second row, and wait at the end. 50, who's 15? 15, bench. Then there's numbers on the benches. Okay. 22, over here this way. Number 22,
22.
22 next row. Number 30. 30, 30 next row. There's numbers on. 44. 44. 44?
Yes.
Okay. $57? No, 57? 58?
All right, everyone, please be seated. I'm sorry.
57, are we missing 57 also?
Yes, 57. 57 come in. 57, also call them for with
All right, could everyone please approach? No problem. All right, ladies and gentlemen, good afternoon. Okay, it's not that bad because it is the new year. Good afternoon, everyone. See, that's awesome. So I am Stephanie Boyd. I'm judge of the 187 District Court, recently moved courtroom. So we used to be down at the other courtroom. So everything for me is flipped. So usually the people sitting over here would be over here. So I'm going to have to get used to turning here and seeing everybody leaning towards this way. You are on the 4th floor in the 187 District Court. So could everybody, which court are you in? Which floor? And who's the judge? And I know what you're probably saying. Why would she ask us that? Because you can't believe the number of times that we have people who come down and we're waiting for a juror, we're missing a juror, and they're off in another court trying to be seated on that jury. And sometimes we're looking for them, and then they come in, and then they're bashful and shy because I've told them, 4th floor, Stephanie Boyd, 187th. And they're like, I'm sorry, I looked up, everybody was gone. So I'm going to allow the state to introduce themselves to you, state.
Hi, I'm Daniel Osborne. Jason Garahan for the state.
And for the defense.
Good afternoon, everybody. My name is Eric DeWalt, and I represent Mr. Brian Parker.
All right. All right, so this is the state of Texas versus Brian Parker. So I'm a firm believer in making people's jobs as easy as possible if I can. So to my left, to your right, probably some of you, we have a court reporter. So the court reporter takes down everything that everyone is saying. If she can't hear, she can't take it down, and we don't have a record. Now, because she's not wearing glasses, she can hear without her glasses. For the people who are wearing glasses, you know what I mean when I say we are now dependent on seeing people's faces, otherwise we can't hear. So she doesn't have that problem. But how we can make her job easier is speak loudly so she can hear, and only speak one person at a time. So everyone, you have some cards. They're very expensive cards that are in your possession. Hopefully you have not sat on them. So I'm going to do this test. And I want you to raise the card if it applies to you. How many of you are in the 187 District Court? Awesome, thank you. So you can lower your cards. So whenever someone says something, if you think it pertains to you, or if there's something you want to say, just raise your card and you will be acknowledged and they will get a chance to speak with you. All right, the charge in this case is felon in possession of a firearm. We're going to get back to that, but I always like to tell people what the charge is up front. And I'm going to say a few things to you, and then the state is going to get a chance to ask questions of you, and the defense is going to get a chance to ask questions of you. So you've got a chance to see all the parties who are involved in this case. Does anyone here recognize any of those persons who introduced themselves? Anyone? Okay. Number 3, who do you recognize? Okay.
Hey, gonna say.
Okay. Now here's the other question. You all have been in the hallway. You met downstairs before. Other than being in the hallway and meeting downstairs before, do any of you know each other? All right. Number 16, 26, 48, 53, 56, and 62. All right, number 16, who do you know?
53.
All right, and how do you know number 53? All right, and which organization was that? All right, thank you. Number 26, who do you know?
Miss Rose? I don't remember. Back there. I'm back here.
Okay. And how do you know her?
We worked in the same company together. She was my former janitorial staff.
Okay. And then 48, who do you know?
Oh, I know number 62.
All right, that was the only person left. And how do you know each other?
We're cousins.
Oh, okay. But not like the series Identical Cousins. I'm aging myself. Only a few people know what I mean when I say that. All right, so the other thing, anyone who is not in this box over here and not on the front row, when you speak, I'm gonna have to ask you to stand if you can, because that'll make it easier for the court reporter to hear. All right, so the questions that are gonna be asked of you by the state, by the defense, by myself, they're all hypotheticals. So when you're asked a question, it is not about this specific case. The only way you'll learn anything about this case is if you are on the jury. Does everyone understand?
Yes.
Yes.
Now, the way a case comes to felony court is through what's called an indictment. How many people have had a traffic ticket of some sort? Don't be shy. Raise your card. All right, you can lower your card. So I've had one ticket in my entire life on the planet. Yay. When I received my ticket, it was back in the day where you were pulled over and they had a paper receipt that they give you and they wrote and they had their little ticket book. Today, I think they do it electronically or something. So if you, let's say an officer pulls you over, accuse you of running a stop sign or not following the rules of the yield sign, which a lot of people don't know what a yield sign is in San Antonio. But so let's say they pull you over for that and they give you a ticket and you accept the ticket. Your accepting the ticket is not saying, yeah, I agree with you, I'm guilty of this. That ticket is just information for you. So if you decide to go to trial, you know what you're being charged with and you know where you need to show up for trial. So an indictment is the same way. An indictment is not an evidence of guilt at all. It cannot be considered whatsoever if you're on a jury. It's similar to a traffic ticket. A traffic ticket that you received is not evidence at all. It's just information. So you'll know, hey, I'm here to challenge the fact that I've been told that I ran a stop sign or I didn't follow the yield sign. Does everyone understand?
Yeah.
Is there anyone going to hold it against Mr. Parker because he's here by indictment? Thank you. The other thing, how many people have seen the shows Perry Mason, Mannix, Barnaby Jones, The Practice, Paper Chase? Okay, I keep going and nobody's raising their hand. This is how old I've gotten. All right, well, Beretta, everybody sees. Thank you. I've gotten your side, right? So anyway, there are certain rights that anybody in the United States, if they're charged with a crime, there are certain rights they have. And one is the right to remain silent. Has everybody heard of that? Anybody not heard of right to remain silent? All right. So what it means is you don't have to testify, right? So the state can't say, oh, let me call you as a witness. That's not on the criminal side. So everyone has that right. There are many reasons sometimes that people don't want to testify. Sometimes people are shy. Sometimes people stutter. Sometimes people are not good speakers. And let me just tell you, I took a lot of speaking courses because I knew what job I would have. And I said, you need to be comfortable with talking in front of people because this is going to be your job. Now, if you talk to my mom, she'd say, oh, she never had any problem with that. She was always talking too much. But for some people, it's a hard time to do that. And when you're testifying and strangers are looking at you, sometimes it's difficult. So there's a host of reasons why people maybe would decide to remain silent. But the most important thing about that is if someone decides not to testify or exercise their right to remain silent, you cannot consider it against them. You cannot hold it against them. You cannot use that when you're deliberating. Does everyone understand?
Yes.
Right. It's not like Bewitched with Mrs. Kravitz where everybody's saying, oh, what would she think? No. Is there anyone, if Mr. Parker decided not to testify, is there anyone who would hold that against him? All right. The next thing I want to talk to you is presumption of innocence. How many people have heard of the presumption of innocence? Anybody not have heard that? All right. For some of you who haven't heard of it, let me explain to you what it is. Everybody is presumed to be innocent. That means for the person who picks up the traffic ticket, when you go to court, it's presumed that you didn't commit the offense. And that presumption of innocence stays with you unless and until the state proves their case beyond a reasonable doubt. So the defense doesn't have to prove anything. When we're in law school, people would always tell you the defense can go to sleep, they can read a newspaper, they can do puzzles, they can play video games. I have yet to see anybody do that as a defense attorney. I've been a defense attorney and a prosecutor, and I never did it. But they can do that because they don't have the burden. They don't have to prove anything. They don't have to prove innocence. The state has to prove beyond a reasonable doubt that someone committed an offense. Does everyone understand?
Yes.
Now, I see your minds working. Your question is, what does that mean, proof beyond a reasonable doubt? Some people have watched television. When I was in law school, there was a definition for proof beyond a reasonable doubt. You had to memorize it. And when you memorize it, you thought you were so great. The first jury trial I had, I knew that definition. My mom was proud. I was proud that I could say it without stuttering and just move right into it. And after that first jury trial, guess what? They changed the rules. There is no definition for proof beyond a reasonable doubt. I still know the definition, but there is not one anymore. So the way people explain proof beyond a reasonable doubt is by telling people what it is not. So car accidents, civil cases, usually their burden of proof is by preponderance of the evidence. Sometimes people will say, like, more likely than not, this happened. That's not the burden here. Proof beyond a reasonable doubt is a higher burden than that. The other burden you have on the civil side is what's called clear and convincing evidence. Clear and convincing evidence is the evidence that is used, usually in child protective services cases, where they're taking away your parental rights and saying you will no longer legally be a child's parent. That's a high burden, but the burden that's higher than that is proof beyond a reasonable doubt. Does everyone understand?
Yeah.
So proof beyond a reasonable doubt is the highest burden. There are two phases in a trial in Texas. The first phase is really what I call guilty or not guilty, right? Either the state proved their case or they didn't. That's phase one. The second phase, if a person is found guilty, you have a punishment phase. If a person is found not guilty, there is no punishment phase because you determine they're not guilty. So in this case, Mr. Parker has elected to go to the jury if he were found guilty. According to the law, he has to make an election either to go to the jury for punishment if he were found guilty or come to the court for punishment. Does everyone understand?
Yes.
The fact that he has made a decision where he would go to for punishment if he were found guilty is not evidence of guilt. Does everyone understand? It's just the rule that he has to make that decision. Is there anyone going to hold it against him because he's decided to go to the jury if he were found guilty?
No.
Okay. Now, is there anyone here who has a reason why they would not be able to sit in punishment of someone or sit in judgment? All right, number 31. Is that a religious reason? I'm sorry, you could stand, please.
The language.
The language. All right, well,
Born and raised here, man. I have a school degree, so I don't know.
I'll address that in just a moment, okay? Thank you. All right, next I'm going to talk to you all about the one witness rule. I'm sorry, number 62?
Yeah.
And what is the reason?
For religious reasons.
Okay. Anyone else? 25, yes?
Yes, I can understand that, Bill. Like the basic thing is.
All right. All right, I'm going to address that issue in a moment, okay? Anyone else? All right, next I want to talk to you about this one witness rule. Everybody talks about the one witness rule. I've never had an occasion where a case has only one witness. I'm going to give you a hypothetical. Do not, I repeat, do not add anything to this hypothetical I am going to give you. This is the hypothetical. A witness comes to testify. They raise their hand. They're sworn in to tell the truth. There is absolutely no question about their credibility. They're testifying. You believe what they're saying. That one witness is able to prove the state's case beyond a reasonable doubt. Now, in your mind, that one witness could be Mother Teresa, it could be the Pope, it could be, someone who's upstanding in the community. Does everyone understand the hypothetical? So there is no question about that witness's testimony. You're not wondering, well, I wonder if it was dark out. That's not a part of the hypothetical. The hypothetical is they come to testify, you believe them. They prove the state's case beyond a reasonable doubt. Does everyone have the hypothetical? Is there anyone here who would still say, yeah, I need more than one witness? All right, thank you. All right, the next question I'm going to talk to you about is language. I think languages are beautiful. I'm originally from Louisiana. I should have taken Spanish when it was offered, but instead I took French because I thought I was going to be living in France. That has not happened. So I end up in San Antonio. And I think languages are beautiful. Some of my friends that I went to law school with, some of them speak 4 and 5 languages. They tried to teach me. The only thing I was able to get is I can say hurry up in almost every language. Everything else was very difficult. I can even say hurry up in Navajo. But the other part, I'm like, maybe I'm getting too old, but I'm working on it. So the trial is going to be in English. Sometimes people may need interpreters. I don't expect any interpreters to be needed in this court, but is there anyone where English is not your first language? If you raise your card, if your first language is other than English. All right, 31, 23, 25. Anyone else? English is not first language. Okay. Number 31. Could you stand for me, please? Yes. What is your first language? Say hurry up in Italian. Yes, I'm putting you on the spot. Thank you. I love Italy. So have you been able to follow through what we've been talking about, the concepts? All right, thank you. Number 23. Yes, what's your first language?
Spanish.
Where are you from?
I'm here, but I live all my life in the city.
Oh, wow. See, languages are so beautiful and the accents are so beautiful. So have you been able to follow everything that we've been saying? All right, and how do you say hurry up in Spanish? Thank you. See, I always test this to see if my friends were telling me right or they're trying to get me in trouble. All right, juror number 25. What's your first language? All right, and your language?
Farsi.
You are the
I'm the Iranian.
no, you are the first person. Well, you are the 4th person we had that speak Farsi.
Yes.
And it's always difficult to find an interpreter.
Mhm.
All right. So you're originally from Iran?
Yes, ma'am.
Okay. Although I know it's not close. One of my friends is from Lebanon originally.
It's different.
Yeah, I know it's different. Yeah. Oh, no, I know. Trust me, I know. But that's the closest to your language I can get. She's taught me different languages. She's taught me some Farsi, some Arabic. Yalla. That's all hurry. Yalla, yalla. All right. But thank you so much. Just have a seat. All right. The next thing I want to talk to you about is time constraints, travel arrangements. Is there anyone here who has some kind of time constraint or travel arrangement where you're leaving? You cannot put the tickets in my name. They're non-refundable. Is there anyone who has something like that? All right, number 55. Anyone else? Wow, usually we have like 40 people who they're going to, see, 34 now is joining it. All right, so.
I work,
Stand up.
I work at night.
What hours do you work?
I work from 6:30 to 10.
6:30 p.m. to 10?
Yeah, and then I do work during the day as well. I'm self-employed and I'm the only employee.
Okay, all right, thank you. 13?
So today I was a little worried. My daughter gets out of school at 3 and usually I have to pick her up. But my husband got her today, but if any other day. Sure.
All right. How old is she?
She's 8.
Okay, this is Texas. Why doesn't she already have her driver's license? Run. All right, thank you. Okay. The car keys are right around the corner. 55.
Yes, I have a work trip the first week of February, then I'm going to Alaska to visit family for the first grandchild right afterwards.
All right, so you're going to work, and where is the work you said?
It's in Utah, work trip to Utah.
All right, and then so Utah is work related and Alaska is,
Family, grandchild first.
all right. Are you going to help or are you going to pass out?
Oh, I'll help.
Okay,
Since the age 1.
okay. And what dates are these, please?
The work trip is the 5th through the 10th of February.
Okay,
The Alaska trip is the 11th through the 25th of February.
all right, thank you. 66.
So I have a work trip from the 16th to the 18th
Of what?
January.
And what is this work trip about?
Projects that I have to manage.
And where are you going? Is this
Oh,
work
I'm sorry,
trip in Vegas?
Arizona, out of state.
Okay, Arizona. All right, thank you. 54.
February 21st to the 5th, Phoenix.
All right, there's a country song about Phoenix. All right, number 10.
I'm not sure how this is my time. I have a doctor's appointment tomorrow.
What time?
2:30.
All right, thank you. All right, what I can tell you all about jury selection is what both sides want is they want people to be fair and who are willing to sit and listen to the evidence. I'm going to tell you 2 stories, and both are true. So my uncle, super intelligent guy. He lived in Grand Cane, Louisiana. He's since passed, but they started the draft for Vietnam. And because he was so intelligent, they kept moving him up grades in school. So when Vietnam came around, he volunteered instead of waiting because all the boys were getting drafted from Grand Cane. So he volunteered and he came back. And I bring that up to you because when you think about it, the country asks so little of us in the big scheme of things. Somebody tell me, well, we have to pay taxes. It's like, yeah, but you got roads, right? The only thing your country asks of you these days, jury duty. They don't even make you vote. You don't have to register to vote, even though not voting affects you and impacts your life. They don't even ask that of you. All they ask of you is to spend some time out of your day to come down and serve as a juror. And everybody says, oh, America, great justice system. America, we're #1. Well, you can't have a great justice system if you can't have a jury trial. And you can't have a jury trial if you don't have jurors. So I know sometimes people see it as a burden. It is. Some people see it as an obligation. It is. But this is all your country is asking of you as far as giving back. So I always tell that story to let people know, if you want to talk about sacrifice, sacrifice is my grandmother having to sign a form for her oldest son to go off to war. Sacrifice is my uncle signing up as a teenager, going to fight off in Vietnam. And this was before the days where you come back and they have mental health all set up for you. You just go there and then you come back. Maybe you come back the way you left. More likely than not, you didn't. Maybe your friends died, maybe not. So when you think of jury duty in those terms, it's not a big sacrifice. We don't even have the draft anymore unless somebody decides to change legislation. You can volunteer for the military or not. The other story I want to tell you is about one of my friends from law school. She decided to do civil law. I always wanted to do criminal law. So one day she said, oh, I'm going to I'm on a jury trial. We can have lunch together. I was like, oh, great. So we meet for lunch. It's like no time has passed. I asked her how jury selection is going. She tells me it's going fabulous. I'm like, who says that about jury selection? It's like, did you have a great judge like me? I don't know. And so we sit down, we have lunch. And I said, what do you mean it's going fabulous? She's like, oh, it's like law school. I'm in the back. I got my head down. I'm not asking any questions and I'm not answering any questions. So I started laughing at her and she said, what's so funny? I said, I think we will be able to have lunch for the entire week. She's like, why? I said, because you are so getting selected for the jury. She's like, no. And I see her at 5 o'clock afterwards. She's like, I'm on the jury trial. She's like, why would you say that? I said, because normally both sides, they'll look and they'll say, juror number 18 never said anything. Well, let's put juror number 18 on the jury. So be sure to talk to them. They will listen to you. And with that, I am going to turn it over to the state to begin your voir dire.
And Judge, can I have a reminder? I have 2 minutes. For me.
Sure. You said 2 or 10?
2.
Yes.
So first off, can everyone hear me?
I have a bad hearing. I couldn't hear what the judge was saying 3/4 of the time.
Okay, well,
What number is that?
I couldn't even hear you, Judge.
15.
What's your number?
Number 22.
All right. Everyone, if you're not able to hear, you need to let us know.
so again, if you guys can't hear me at any time, please let me know. I'm gonna try and speak as loudly as I can. As we mentioned earlier, my name is Daniel Escobar. I want to work with the security man who represents the state of Texas. Of the work for the Marion County DA's office. What we're doing right now is what's called voir dire, or in other words, jury selection. So there are 3 goals for that. 1, I'm going to talk to you guys a little bit about the law, try and educate you on as what's going to happen. 2, think about it. There may be times when I'm going to point some people and ask for you to answer the question. It gives you bad flashbacks when you were in kindergarten. I apologize. I never made you wishes.
All right. Just pause for a moment, please.
I'll just go now.
Okay.
That's also indicating an important part. The court reporter, she's gonna need to hear your responses. So whenever I ask a question, if you could stand up and talk loudly so that she can take down what you guys are saying, because it's important for the record. But the other final part of voir dire is that we are trying to find 12 fair and impartial jurors for this case. And what do I mean by that? So an impartial juror is one where you're able to render judgment without your personal biases coming into play. We all have biases to some degree, but the important part here is that there are no biases that dictate that you're going to say one way or another before you even hear any of the facts. Because that's the important part. Listen to the facts and then make your decision. We don't want people for either side to come in and decide before they've heard a single thing. So part of the ground rules for what's going to happen. I can't talk about the facts. Neither side can. There aren't any right or wrong answers. I'm not going to try and convince you guys otherwise. That's not what we're here for. We just want to learn about you. We just want you guys to be honest and participate. Now, part of what I'm going to let you guys know is that usually it's the first 12 jurors who get picked because you guys are in the first ones up. So just giving you guys a hint, talk more, and we will probably be able to see what happens. Okay? Doesn't mean the rest of you guys are safe though. Sorry. So bias resulting from personal experience. Now, who here knows who those 2 individuals are? Juror number, man, what's the number? Okay, it's from The Simpsons. It's Moe and Bart. Now, what would Bart do constantly to Moe? Constantly prank phone calling. If you guys can, go on YouTube. It's hilarious, but it would annoy Moe to the point to where he threatened death on a little boy. Now, would Moe's disliked experience with Bart make him a biased juror in a telephone harassment trial? We would all agree. Another way that bias can kick in is from personal habits. Now, sir, juror number 20, who is that? Willie Nelson. What is Willie Nelson famous for other than country music? Smoking marijuana. Do you think that he would be a fair and unbiased juror in a marijuana possession case? Probably. Is there anyone here who would disagree with that? That's kind of what we're trying to look for here, ladies and gentlemen. So it's two phases of trial. It's guilt, innocence, and punishment. Okay, so guilt, innocence, it's did the state prove that the defendant committed the alleged acts? Okay, it's going to include things like on or about in Bexar County, Texas, the defendant, and then we're going to have to actually go into the specifics of the law. Okay, that's the first portion. The second portion is punishment. Again, Texas has a bifurcated system where it's guilt, innocence, then we go into punishment. That's going to be something that where we consider things like, well, what's the situation here? Background, things like that. So what brings us here today? Felon in possession of a firearm. So these are what's called the elements of the case. The state has to prove these beyond a reasonable doubt. So on or about, so we have the date. In Bexar County, Texas, we have to tell you the where. If it didn't happen in Bexar County, it shouldn't be in this courthouse. The defendant, someone has to identify someone and say that's who committed the acts. Having been previously convicted of a felony, did intentionally and knowingly possess a firearm before the 5th anniversary of the defendant's release from prison, parole, or felony probation at a location other than where the defendant lived. Okay, all important. So one thing I want to start with, intentionally or knowingly. So one thing that I could do is an example. As I'll see here, it's a legal pad, right? Right here. If I were to say, I'm about to pick up my legal pad, and I did. Sir, juror number, what's your number? Yes, juror number 33. How do you know I intended to pick up the legal pad? Yeah, and did you see me do it? Okay, so it's pretty easy to say I intended to do it, right? Now, I'm going to pick up my legal pad. See if I can't drop it. You're number 33. What just happened at above? Okay, and you saw me pick up a bottle of water. Did I say that I was going to pick up a bottle of water? No. But obviously, because of the situation, the facts and circumstances, it's obvious to anyone who saw what I did that I knowingly picked up the bottle of water. I didn't outright say I intended to. I probably didn't intend to. It's just one of those things that is the facts and circumstances of the case that dictate how you make that determination. It's not something where you have to be a mind reader. So let's talk a little bit about guns. So is there anyone here who has a license to concealed carry? Okay. Juror number 7, you can put your card down whenever I say you know. Juror number 7, 54. Sorry, you guys all kind of dropped and picked up. 33, 44, 45, 55, 65, and 58. Okay. Law has changed recently. Now, for those of you who answered juror number 7, did they make you do a background check?
Yeah.
Why did they make you do that? You know?
To find out if you're
Right. Again, part of this is part of it used to be where we used to look into people's background to make sure that we're not allowing people to carry on them weapons when they have some sort of criminal history. Now, specifically here, I want to break it down. So before any felony conviction, it's legal to possess a firearm in your home, and it used to even be in your car. Now you can kind of carry it around on your person at all times, but it's how easy to break it down like this. Now, once you are convicted and you are released from confinement, you are no longer allowed to have firearms in your possession. And that only changes 5 years after you've been convicted, or either released or your supervision has been ended. And then at that point, you can still only possess firearms in your home. Does everyone understand that? So before, you're fine. Once you're convicted, there's a 5-year period where you cannot have it at all. But then after that 5-year period, only in your home. So is there anyone here who that statement would apply to? I understand the law, but once someone has served his time for a crime, he can't be punished again just for having a felony conviction and possessing something. In other words, you will never find a defendant guilty of felony possession of a firearm, even if we proved all the elements beyond a reasonable doubt. Is there anyone here who that would apply to? Okay. Now, possession, that's one of the elements. It's care, custody, and control. Now, this may not always be obvious in some circumstances. Some it is and some it isn't. But here's what you should be looking for. One, where is the item located? If it's in someone's pocket, pretty easy to say, possession. Those are the easy ones. How many people have immediate access to the item? Okay. It's how many people can just go in, and if it's in your pocket, usually it's probably only going to be the one person. Maybe other people. We don't know their lives, but it's usually just the one. How close is it to the defendant? If it's something where it's miles away, it's kind of hard to say that they possessed it at the time. Does the defendant admit to knowing about the item and its location? If someone says, yeah, there's a bloody hammer in my closet, pretty easy to kind of piece together that they probably have an idea it's there. And they had possession and control, care, custody. Was the defendant committing other crimes? Possibly here it could be if it's a robbery and someone has a gun on them, that could always be something that plays a role. Again, care, custody, control, what were they doing with the item? Was the defendant showing consciousness of guilt? In some instances, it may be as easy as, I'm sorry that that's there, or I didn't need to have that, things like that. You're not always going to have all these line up perfectly because it's real world, it's messy. Things don't always work out that way. But you have to look at the facts and circumstances of the case in order to make that determination. Now, stepping into burden of proof. The burden is on the state to prove all the elements beyond a reasonable doubt. Does everyone understand that? Okay. At no point does that really shift to the defendant at all. It's our job. And if we don't do it, what's the verdict? Ma'am, what's your juror number at the end of the math? Juror number 15. If we don't meet all the elements, what will be the verdict? Well, not guilty, but it's the right idea, ma'am. That would be it. Not guilty. It's our job. So beyond a reasonable doubt, what do we mean by that? So the judge mentioned, I can't tell you what beyond a reasonable doubt is. Can't give you a number. I can't give you a phrase. We wish we could, but we can't. But what we can say is what it's not. It's not beyond all doubt. If anyone could do that, that'd be pretty impressive that they could prove something beyond all doubt. It's not 100% beyond a shadow of a doubt. Again, that's almost impossible for anyone to prove. It's, can you reach the reasonable conclusion? That's all we're asking here. You're not required to leave your common sense at the door. Okay, you can bring in common sense. So is there a doubt? Is it a reasonable doubt? And does it go to an element? Those are the things you need to consider. Okay. Now, juror number 1. What is that? Okay. And are there pieces missing from that puzzle? Can you tell? Okay. So even though there are pieces missing from the puzzle, how do you know it's an element? Okay. You have enough information to make that determination. So you don't need 100%. That's what I'm trying to illustrate with that. Is that you can use the pieces and form the picture. It's not always going to be 100%. It's not always going to be fully revealed. But sometimes it's enough. And that's what we're looking for. Juror, ma'am, what's your juror number? Juror number 13. Have you gone to the movies recently? Okay. Juror number 12. Have you gone to the movies recently? Okay. So let's pretend it's one of the times you went to the movies. And as you're walking into the theater, you kind of can see dark storm clouds. You get that little smell in the air as if it might rain. It's not raining yet. There's all these things that are kind of there. And you watch your movie, get out of the movie theater, and when you get out, there's water everywhere. What would it be reasonable to conclude? Okay, but did you see it rain? Okay, you didn't feel it rain, but you have enough to go on and say that it rained. Would it be reasonable for me to say that the mayor of San Antonio had a fire engine and hooked it up to a water supply and sprayed the parking lot? Could it happen? Possibly, you'd probably get fired and be a great news story, but it's not reasonable. Could doesn't always mean reasonable. So one thing that I mentioned in the who, what, when, where was the why. I never mentioned that because the state does not have to prove why. It's not an element that we need to meet. Again, this is specifically what the on or about in Bexar County, Texas, the defendant, having been previously convicted of a felony, did intentionally and knowingly possess a firearm before the 5th anniversary of the defendant's release from prison, parole, or felony probation. And again, if it's before, the house exception doesn't apply. That's it. So, if you believe all of those things beyond a reasonable doubt, the state's met its burden. We've done our job. Now, here's some typical evidence that you can see. It's officer testimony, video, photographs, possibly physical evidence. All these things could play a role. Okay. What probably isn't going to happen, hearsay, any type of recorded lay witness statement. If we have someone else coming in saying, this is what I saw, you can't just play that out loud. One important thing, police reports. You're not going to get any of those. It's just what the officer's writing just to make sure that he can refresh his recollection later. You're also not going to get any type of out-of-court transcripts. Now, is there anyone here that would not believe an officer because of his job? Please raise your cards. Juror number 34. Okay, anyone else? It's okay. Juror number 29. Juror number 45. And I'm going to ask you guys if you could keep your cards up. Can I ask juror number 29, why would you have that opinion?
I had a bad experience with an officer a few years ago. I had gotten, it was a minor issue that I got pulled over. And
Excuse me, just
he
one
took me to
second.
the-
Daniel, if you could like not stand in front when they're speaking.
Sure,
and
sorry.
help. That's okay. And if you're not on this side or on this first row, I need you to stand.
Oh.
That makes it easier to hear.
Because I had an issue with an officer. They pulled me over for citation. And he ended up arresting me for that violation. I went ahead and I fought it. Still didn't. He ended up changing his story.
Okay. Now, would that experience make you, unable to be fair and unbiased in this matter?
It'd be hard to tell.
This is one of those things where it's a yes or no answer, sir.
Yeah.
Yes. Okay, thank you. Juror number 34.
What was his number?
It was, sir, can you share it one more time?
29.
Juror number
29.
29. Juror number 34. You said that you wouldn't believe an officer just because of his job. And why would that be? Can I ask?
I mean, a lot of what I've seen like in the media with police and brutality and a lot of injustice that I've noticed on social media, things like that. That's kind of where I base a lot of it. It's more like not an exact experience that I had, just off of like what I've seen.
And do you think that what you just described, would that make you be unable to be fair and unbiased here in this trial?
Yes.
Thank you. Juror number 45.
I've just had that experiences with. Not my personal experience, but. What I know close.
And do you think that prior experience, do you think that would make you be unable to be fair and unbiased? Yeah. We're gonna move on to the next part. Oh, well, juror number 10.
Yeah, yes, sir. I was pulled over by an officer a few years back. And I was in my late early 20s and I was driving a sports car. And I believe he was racially profiling me.
Sorry that happened, sir. Do you think that would make you be unable to be fair and unbiased in this trial?
I think it.
Think it would? Okay, thank you, sir. Now, this goes into the similar answers to the first question. Has anyone here ever had a negative experience with a police officer? Okay, raise your cards, please. So juror number 29.
Yes.
Juror number 58. Can you speak on that? What are you talking about? Or what happened?
I was pulled over and given a traffic citation and berated by a police officer. And he cited me for something that wasn't illegal. And so fortunately I had a dash cam and I sent it to the DA and DA dropped the charges.
Okay, and would that experience make you be unable to be fair and unbiased here in this matter?
No, that was just one particular officer.
Thank you, sir. Anyone else who ever held up the card? Juror number 35.
My only ticket, I was 19.
Mhm.
I was driving, my old car. I was pulled over for driving over the speed limit. And, he said that I was going 56 miles per hour, something like that. Like my car shakes at 45.
Mhm.
And he started, I said, when I said, what's the problem? He goes, we just are speeding, like it's 35. He goes, no. I mean 45. He goes, no, it's 30 here. So I was passing area where and the light was green.
Mhm.
So I didn't realize the thing had wrong. But I'm like, well, I could have been going 45 because that's what I was going. He goes, no, it's 30. Like he said I was going 50. So then he was getting upset. So I'm like, okay. But he was like, you need to check your speedometer. But it was not, I was.
So do you think that experience with that officer, would it make you be unable to be fair and unbiased?
No.
You think you
No,
could still be
goodness.
fair and unbiased?
That was one of them like that.
And thank you,
But I
ma'am.
was,
I understand, man. Thank you. Juror number 52.
For not stopping on a stop sign and then light and said that there was a lot of accidents there, but I was there. There weren't any, on top of that, I have people who don't, have a really good relationship.
So do you think that those experiences would make you be unable to be fair and unbiased in this trial? Okay, thank you, ma'am. Is there anyone else? Yes. Is there anyone else? Okay, thank you. Juror number 61.
My situation was basically this kind of the same, speeding one time and the police officer was very rude to me. So basically discussing.
And do you think that that experience would make you be unable to be fair and unbiased in this trial?
I don't think so. I think it's the individual police officer.
Okay, understand. Thank you, sir. So again, what I was trying to get at here with the slide or here with what I'm asking is, can you be fair? And can you take those other experiences that could always be there? And could you just say, I could still look past that to just look at the facts? We all have different experiences, so it's understandable that these things can happen. Next, have you, a close friend or family member, ever been convicted of being a felon in possession of a firearm? Is there anyone here who that would apply to? Okay, juror number 51. Is there anyone else? And juror number 35. Now I'll ask just you two. I don't think there's anyone else. So juror number 35, do you think that either your experience or someone else's experience of someone close to you, do you think that would make you be unable to be fair and unbiased in this trial?
no,
Okay. And then juror number 51.
No.
Thank you. So part of it here, you are not allowed to let bias, prejudice, or sympathy influence your verdict. It's just looking at the facts. And then let's assume, everyone for a second, that you believe that the state proved beyond a reasonable doubt the defendant committed the charged crime. Would any of you still say, I still need more? Is there anyone who's always going to say, I always want that one extra thing? Anyone? Is there anyone here whose personal beliefs, feelings, or religious beliefs prevent them from sitting in judgment of others or being a juror on this case? I know we asked that earlier, but I just wanted to see if again that would apply. So juror number 22, juror number 34, 62, 49, 52, and 75. And then was that 59? Thank you. That was 79. Sorry about that. Or 62 or?
Oh, I'm sorry.
Yeah, everyone keeps holding it upside down. Just wanted to make sure to double check. So I'm just gonna ask here, it's a general, well, 1 to 4. Really, I may just ask if anyone has strong opinions that are outside of the middle. But what is your opinion of the criminal justice system and your rights? Is there anyone who says it's terrible, it takes our rights away? Concerning, it interferes with our rights. Helpful, it looks out for citizens. Or beneficial, it protects us from the harmful actions of others. So let's start with number 1. The criminal justice system, it takes away our rights. Is there anyone here who that would apply to? Anyone? Fair. Number 2, the criminal justice system interferes with our rights. Is there anyone here who that would apply to? Okay. 3, it's helpful. The criminal justice system looks out for citizens. Is there anyone here who believes that? Okay. Here, number 1, 3, 5, 15, 35, so yours is reversed. 42, 50, 59, 62, 61, and 72. Is there anyone? Yes, ma'am. And so again, considering the criminal justice system, it's which one of these does applies to you? And the third one that I was asking about is that it looks out for citizens. Is that something that you believe? Okay, and you're number 16. Yes. And 63, anyone else? Last one, it's beneficial. It protects us from the harmful actions of others. Is there anyone else here who would believe that? I'm gonna guess, since no one else raised their cards for the first 2, that the rest of it applies to the rest of you. Is that true? So before I end, I always like to ask this. Is there anything that any of you think, wow, Daniel, you should have asked this of me or asked this of the group? You're number 5. Mhm. Okay. Okay, no, and I understand. Thank you, ma'am, for sharing that. That may be something, do we approach that after, Judge, or?
Yes.
Is there anything else? Any other questions or anything else? You're number 55.
And my son is a police officer. Just want to make sure you know that.
Okay, so is there anyone else that applies to?
I have a minute.
Okay, and that's juror number 6. Anyone else? Juror number 59? You are a police officer? Thank you, ma'am. Juror number 28?
My brother.
Okay, so family member who's a police officer. Juror number 28. Juror number 35.
Some family.
I'm sorry, can you just?
I have family that were in police force.
Juror number 38. If you could stand up.
Yeah, with my job, I currently work side by side with the constables as a
Okay. Juror number 39.
Family and SCPD and parents.
Okay. Juror number 65.
Yes, I have a brother-in-law, and nephew who are police officers.
Thank you, sir. Juror number 52.
My brother-in-law and my.
Okay, thank you. Juror number 73.
My sister is a scene investigator.
Thank you. Juror number 75.
My fiance is a detective and sergeant in the police department for SAPD.
Okay, thank you. Juror number 11.
Just nephews that are. That's all.
Thank you, ma'am. All right, I think with that, we're good. So pass it on to defense. Thank you, guys.
May I please call your honor?
Yes.
Thank you. How many of y'all are tired? Thank you. Hold your hands up, okay? You know how hard it is to go last? We all listened to the judge and she covered all these elements that we're gonna go over with the trial. And then the state did the same thing. So what am I gonna do? I'm gonna get up and do the same darn thing. And y'all are gonna roll your eyes going, Eric, how can you go over this one more time? But everybody takes it at a different angle, okay? basically the state said, we want everybody that can be fair and impartial. Okay, if we could do that, raise your hand, we take the first 12 and we'd go at it. But there are biases that are deep inside us. I became an attorney 22 years ago. When I first started practicing law, I was running around the court system and someone broke into my car and took my briefcase. It had my day minder. Do y'all remember what those are? It's a page that you turn and you write everything down. We didn't have cell phones or iPads or any of that. But I went to every court room in this courthouse and told the judges, hey, I had my day minder stolen from me, broken into my car, but I promised to be here for the next month every day. And I pretty much know every case that I have. But if I miss, can you call me? I'm telling you right now, here's my cell phone number. And the judge goes, Eric, by the way, can you take a court-appointed case today? I'm giving you a case. You can represent him via defense counsel. I said, okay. And guess what the judge gave me? Burglary of a vehicle. You think I was the best guy to defend that individual on that day? I'll tell you right now, no, I wasn't. Okay. The judge was teasing. I, declined. But it tells you that you have deep-rooted biases. And at that time, I couldn't be fair and impartial. But you know what? If I would have read the facts of the case and said, if this individual did not do it, can I apply the law? In the last 22 years, I've had this position right here. I've been with the DA's office. I prosecuted in the Family Violence and Victim Protection Division. I prosecuted in the regular criminal trial division. We've all worn many hats. I know the judge has been a prosecutor, defense attorney. I'm a magistrate judge, a part-time magistrate judge. And so when someone gets arrested, I have to say, did the officer reach reasonable suspicion, probable cause? I have to set a reasonable bond. Doesn't say anything about guilt or innocence. It's saying, let's go through the process. A lot of you raise your hands that y'all have family members in law enforcement, or you are in law enforcement. And that I applaud you. I mean, that service, giving back to our community, is needed to protect our community. But you got to follow the rules. Wouldn't you agree? When I say, who am I defending? And I say this every time and everybody chuckles. Do you know who I'm defending today? My mother. I always say my mother because nobody has more rights than my mother. You can't kick open my mom's door. You can't look in her closet and see what she has in her drawers. The problem is a meth dealer has those same rights. I hate to say it. In the United States, we have rights. I'm here to defend your rights. Everybody has rights. Nobody has more rights than my mom. All I'm here to do is to make sure they do their job. The judge said it, and I kind of chuckled, and I don't know if y'all caught it. The defense attorney has the easiest job in the world because I don't have to do a darn thing. I can sit here, I can sleep, I can, raise my eyes and kind of look around, as long as I'm making sure they're doing their job. I represent everybody in here to make sure they do their job. And if they don't, I'm going to jump up, I'm going to object, I'm going to say, Judge, they can't do that. Once you hear the story, they already said, if they don't prove every element beyond a reasonable doubt, your verdict has to be. Say it again, man. It's okay to say it. It's easy.
I don't want to say it again.
Innocent, not guilty. Okay. If the state says, boom, you have all the evidence in front of you right now, and is this individual guilty of the allegation put forth? Right now, you'd have to say, it's okay to say it. Not guilty. Right now, they haven't given you any evidence. None of us have. Okay. There are different classifications of crimes. There's a Class C misdemeanor. We're going to talk about this in a minute. Class C, y'all know what that is? It's a crime that doesn't hold jail time. The fine is $0 to $500, and most of y'all know it as a traffic ticket. Okay. Then you get to a Class B misdemeanor, and that's a $0 to a $2,000 fine, and 0 up to 180 days in jail. It's almost 6 months, how you calculate it. Whoa, we just went up to someone can serve jail time on a Class B misdemeanor. Then you keep going up, there's a Class A misdemeanor. The fine is up to $4,000 and you can serve up to a year in jail. Then there's what's called a state jail felony. It's a quasi felony and you can serve up to 2 years in prison, 180 days to 2 years in prison. And then we jump up to the 3rd degree felony. 3rd degree felony, you're facing 2 to 10 years in prison. There's a 2nd degree felony, which is 2 to 20 years in prison. And then there's a 1st degree felony, which is 5 to 99 years in prison. And one more all the way over here, capital murder. Capital murder is life or death. You understand that? Did y'all see the range of the classifications of crimes? If y'all could repeat all that, you just passed Law School 101. But now I have a question for you, and I'm going to ask you to hold your hands up high. How many here have gotten a speeding ticket? Raise your hands, please. Raise your hands. Okay. No, keep them up, keep them up, keep them up. Now, how many of y'all in that speeding ticket believed you were innocent? Leave them up if you believed you were innocent. Okay, okay, keep them up. Keep them up if you believed you were innocent. Sir, what happened to your ticket?
It went away, it disappeared.
How did it disappear?
They never got fined.
Never got filed. Awesome. Ma'am, what happened to your ticket?
I was slowing down in front of the seat. I still got the ticket.
Okay, you got the ticket, but you believed you were innocent. Okay, and so what happened with the ticket?
I had to.
Whoa. Hold on, who else has their hand up? 22, sir, you said you got a ticket?
Yes, I did.
What happened with the ticket?
I paid it. I didn't want to miss it.
Paid it, didn't want to mess with it. 34, what happened to your ticket?
Defensive driving.
Defensive driving, 66.
Defensive driving.
God, all of y'all are innocent and y'all pled. Why are y'all pleading to a crime that you believe you're innocent? Because if you showed up, what would have happened with the officer? How many believe the officer might not tell the truth, embellish the truth? It's easier to take a plea. Why might someone take something to trial?
They know they're innocent.
Because they believe they're innocent. Because they believe that the facts won't stack up. Because they believe that the state cannot prove every element of the offense. Do y'all understand why we might be here today? Okay, thank y'all. There is a thing called the Innocence Project. Has anybody heard what the Innocence Project is?
Yes.
Who said yes? What is the Innocence Project?
They go after people who have had charges or have been convicted and they try to prove their innocence past, all the court and all the stuff's done. They try to.
Okay, so now we have some cases that have gone to trial, not pleading out when you think you're innocent. Don't plead out. But that was bad. But these people have gone to trial, been convicted, and later on there's a project that are proving some people innocent, right? So sometimes we've convicted the wrong individual. Would you agree?
Yes, sir.
Okay, we have an awesome system, but it's not the end all be all. And if you apply the law correctly, it works. The state was talking about different levels of proof. Has anybody heard of the scintilla of the evidence? That is the most minute piece of evidence around, okay? Then you go to reasonable suspicion. And just like I walked over here, the levels of proof get larger. Okay, so the scintilla of the evidence is way over there. And then you get to reasonable suspicion. That's where someone walks in and they smell marijuana. There's nobody in the room. There's nobody in the building and they smell marijuana and they're like, I got reasonable suspicion that something happened here. Okay, it's out there, but they're not going to pin it on anybody. There's just a heightened awareness that something's going on. Then you have probable cause. Probable cause is what an officer needs to arrest somebody, to take their liberty away. They have probable cause that this might have happened, And that's what you get when you arrest somebody, you take them down, you magistrate them, and they can bond out. Then they have to show up to court. Then there's clear and convincing evidence. So above what the officer needs, clear and convincing is what you need over in civil court. That's what they need to take your children away. So if your son comes home, or if your son goes to school with a black eye, the teacher's like, what happened? And he's like, oh, I was playing football outside. And the next day he comes with another black eye. And the teacher goes, hey, what's going on? They can call CPS. Well, CPS can take your child away with clear and convincing evidence, but they need to interview those parents and say, is the kid in football and what care have you done? That must be very clear and very convincing if you're going to take my children away from me. So to me, that standard is high. It has to be clear and it has to be convincing. Now we go over here to beyond a reasonable doubt. That's the standard of proof you need in every single criminal case that I mentioned here. And the state said it. If there's a doubt and it's reasonable, then they don't meet their burden. If at the end of the day you say it might have happened, could have happened, it looks like it might have happened, all of these are not guilty. It's a hard thing to say. I understand that, ma'am. You're sitting in a court of law, and to pronounce, hey, innocent, that's hard to say. But when you apply the law, I am looking for individuals that can theoretically put a black robe on and sit in this jury box, because you are going to be the judges, the exclusive judges of the facts proved by this table. Everybody sitting here should have a black robe on because you're a judge, and you got to say the state met their burden and prove the case beyond a reasonable doubt. I don't have that doubt. I don't have that reasonable doubt. If not, hey, state, next time, sorry, because you're protecting all of our rights. Does everybody agree with this so far? I thank you. What are some of the evidence that the state might show? They put up a little list of things, but what is evidence? Testimony? Might someone testify? Okay, eyewitness testimony is someone seeing something and they tell you what they saw. I saw X shoot Y, Y fell, and I can ID him. Okay, it's not, I heard it, from my grandmother that Joe might have shot Jim. Okay, that's hearsay. So an eyewitness testimony, someone can testify as to what they saw. But the people that sit here, and I'm pointing because this is where the 12 are going to sit, are the exclusive judges of the credibility of the witnesses. One thing I do not like is a one witness case. You want to know why? Because when there's two witnesses, there's two sides to every story. There's always, people see things differently. And I'm asking y'all, can y'all sit here and be fair and impartial and apply these rules? They're going to give you the rules to apply to this case. And I'm asking if you can apply them equally. What is some other type of evidence? Maybe fingerprint evidence, maybe video evidence. Anything that's corroborating evidence is something that proves something did or did not happen. Now you can run around the corner and see one person holding the gun and one person laying on the gun, and you cannot say beyond a reasonable doubt that he shot him. But what are they going to do? They're going to get fingerprints off that gun. They're going to make sure that bullet is traced to that gun and it's not someone in a window shooting. Y'all have seen the shows. All I'm asking you is to use your common sense. One, it is a great honor, I think, at the end of a trial. I've never talked to a jury. Haven't talked to a jury that is so satisfied at the end. This is the worst part. Y'all waited outside for half a day because the system works slow. It has to work. But y'all came in and y'all aren't even here yet. It's the 12 people on here that really get to toy with their emotions, stating, you know what? I got to be a judge. And this is what I thought. And here's my conviction. And if I don't believe what the other 10 believed and we're two over here and we see it different, you stand by your convictions and you say, I don't believe it happened, or I did believe it happened beyond a reasonable doubt. Is that fair to say? Does anybody disagree with me? I'll raffle through this so fast, y'all are probably like, hey, hurry up, sit down. Honestly, I am going to sit down because I've heard everything the state had to say and the judge had to say, and I've been taking notes. But officers, I thank you. The state went through the questions of, is law enforcement needed? Yes, it's needed. We have a great society out here, but I'm asking you to be fair and impartial and apply the law and hold the state, because they took an oath of their office that they won't bring a case to you that they don't believe. So I'm here to hold them to their burden. Will you hold them to their burden? That's all I ask. I thank you for your time.
All right, ladies and gentlemen, I am going to have you go outside. These are the rules. Everyone look to your left. Look to your right. That is your jury buddy. Make sure that they realize they're in the 187 District Court, 4th floor with Judge Boyd. If you get lost, if you tell somebody, I'm supposed to be in the 187. If you tell them it's Judge Boyd, I'm the only Judge Boyd in the courthouse. So what's going to end up happening is the people in the box, I'm going to need you when you step outside to take all of your personal items out of the box. Everyone else, we're going to take a break. I will say, make sure you're lined up outside 10 minutes to 4. All right. So everyone has to leave together. No one can remain in the courtroom, and we'll call you back. All right. Everyone, please rise for the jurors.
Okay, buddy.
Oh, yes. Leave your numbers behind, everyone. They're very expensive.
Leave your numbers. I'll call you. There. Don't take my numbers. I'll call you. I will. What do you read?
All right, so these will be the jurors. Number 1, 2, 4, 7, 11, 14, 18, 21, 24, 27, 28, 32. Any objections from the state?
No, Your Honor.
Defense?
Your Honor, 24, is that one?
Yes.
24, that's the one, no objection, Judge.
All right. And the alternates will be 44 and 46. Any objection, state?
I'm sorry, Your Honor. 44 and 46?
Yes.
Okay, no objections, Your Honor.
Defense?
No, Your Honor.
All right, let's bring the jurors in. Please stand. Everyone, you can sit anywhere.
You can sit anywhere. We also have this front bench. Because not everybody's gonna get a chair. No, we took away 14. Yeah. Have a seat. Not everybody's gonna have a seat. Anywhere? Anywhere. Just more on this side, right? You can have a seat right there.
Everyone, do take a seat anywhere.
First row for the bench. You can sit right here, and from right here, everybody else have to stand.
All right, everyone, please be seated.
Come on in.
All right. Everyone, I'm going to call the names of the jurors for this case. When I call your name, please take a seat in the box to my left, probably to your right. Meredith Woolard. Grace Bacho. Jaime Lopez. Derek Runner. Rose Soriano. Lizette Torres. Jessica Garcia. Veronica Garcia. Jared Macharo. Carl Alsup. No, what is your name? All right. You can remain if you want to. Jay Endicott. Micah Carlusek. Jeffrey Richardson. Aaron Ramirez. All right, ladies and gentlemen, thank you so much for your service. If you would like, I can have you brought back tomorrow for another panel. See, everybody, everybody always does that. Let it marinate,
That's all day.
Yes, yeah. So you can come back for day 2. You should have a white sheet in your possession, and that sheet is for your service today, showing that you did serve. There is a payment that you received for being here today. If you want, you can donate it. There are many organizations downstairs in the central jury room where you can donate that to, and they'll give you a list of organizations, or maybe it's a different organization that you want to donate to. You can. Otherwise, what will happen is probably 2-3 months from now, you're going to receive a check in the mail. You're going to wonder if it's a hoax. Then you're going to remember the great time you had with Judge Boyd in the 187th, and you're going to have lunch and enjoy the Riverwalk. So with that being said, you're always welcome to stop by the 187 District Court. Courtrooms are open to the public. I think it's very important for people to know about the process. On this side, of course, it's adult court. Criminal cases is what we handle. I never encourage anyone to go to the juvenile courts because they're juveniles, or go to Child Protective Services Court because it's dealing with young children and it's pretty traumatic for them. So otherwise, you can always stop by the 187 District Court. So have a great rest of your day.
Thank you, Judge.
You're welcome.
Thank you.
Sorry.
Right.
Thank you.
Oh, wait, ladies and gentlemen, we're in the record. Before I release you for the day, I'm going to give you some instructions. First things, please be seated. First things, I always try to have us out of here by 4:30. That way you can avoid rush hour traffic and avoid constructions. Sometimes that's not possible because I don't like to stop if we're in the middle of a witness. We're going to start tomorrow at 10 a.m. But if you can imagine, whoever built the parking garage didn't realize that everyone who works at the courthouse will be parking at the parking garage. So that tends to fill up because when you think about it, jurors park at that garage and everyone who works in this building parks at that garage. So even though I say that we will start at 10 a.m., if you want to find parking, it would probably be best for you to be here earlier than that. Otherwise, you're going to be driving around trying to find parking. What I can tell you is court, for a lot of courtrooms, they either start at 8:30 a.m. or 9 a.m. The reason why you're going to be brought back at 10 a.m. is because I have a docket I have to take care in the morning. And usually when we're starting a little late, it's because I have a docket I have to take care of. So this isn't, even though this case is what we're here trying, this is not the only case that I have on my docket. You will notice sometimes that people will come through this door for me to sign certain things because I'm also presiding judge for all the courts. So what will end up happening during this week is I will get officers and different people coming in to see me to have me sign documents. It has absolutely positively nothing to do with this case. So I know it's hard to ignore sometime, but please ignore that. And we have different offices in the courtroom. We have a liaison office who was sitting in that chair there, who you saw walking in and out. She had different paperwork for me to sign. So it has absolutely nothing to do with this case. The temperature in the courtroom. Sometimes it's super hot in here. Sometimes it's super cold. Bring a jacket. It's better to have it and not need it than to need it and not have it, because I have no jackets to give to you if it gets too cold in here. Drinks. You can bring water, your coffee into the courtroom, but make sure it has a lid on it, because I'm trying not to have any spillage on the carpet. You're not going to report to this courtroom when you come tomorrow at 10. Deputy Laura is going to show you where you report in at. And that way you will be in the back, and then we'll call you out and we will be ready to go. And we will start exactly at 10. We can't start at 10 unless everybody's here at 10. So if there's one juror who's not here, we have to wait for them. If there's an issue that comes up, Deputy Laura will have all of your numbers, and she will give you the number for you to call in. Like if there's an accident on the freeway or some emergency comes up, so you can call in and let us know. I don't expect this case to involve any publicity, but if for any reason you see anything about this case on the news, on TV, or wherever, any type of social media, ignore it. If somebody wants to talk to you about this case, tell them you can't talk to them about the case because you're on the jury for this case. Do not do your own investigation. Do not do any research. Everything you know about this case and you need to know about this case will come from inside the courtroom. So there's to be no research. Does everyone understand? All right, so any questions? Yes.
Thank you, Judge White. In past, I've served on jury and they've given us like an idea how long it's gonna take. Do the counselors have any idea, just in case my manager at work says, hey, you know how long can you come?
All right. I'm anticipating, now mind you, juries take a life on their own, but I'm anticipating Friday at the latest. All right, any other questions? Yes.
Yes, Judge, what about breaks? How often you get breaks there too? You know, restroom breaks.
Oh, this is the thing. If anybody needs a break, do that. And what will end up happening is Deputy Laura will see it, or either one of the counsels will see it, and they will say, Judge, they need a break. Because a lot of times, if there's evidence being presented, I'm looking at that. And sometimes I'm not looking at the jurors because I'm paying attention to different things based upon rulings I have to make. So you need a break. And we always break for lunch here. So lunch break is usually at 12. Oh, they're looking at me like, no, she's not telling the truth. We do our best to break for lunch. All right. Is it? Well, let me correct that. I will make sure that you all have a break for lunch. Are any other questions? Yes.
And do you anticipate 10 to 5?
No, I'm going to try to get us out of here every day by 4:30 so that you can avoid rush hour traffic. The only exception to that, I don't like to break in the middle of a witness. Okay. Any other questions? All right. So I will see you all back here tomorrow at 10 a.m. All right. Thank you all so much.
Judge, I have one quick question.
Yes.
Administrative question. For the parking path, do you do the same thing every day, just get it validated, or how does that work for parking?
Deputy Laura will explain that to you.
All right.
All right. She has the secret code to the validation.
Okay, there we go.
All right. Thank you. Everyone, please rise.
Hold on, and we'll talk.
All right. So is there any video or anything that I need to view?
There's video, but
The only motion in limine I would have,